How is your company aggrieved by the challenge that is brought in this case? I gather this is your version of Mifepristone is the only product you are currently marketing. Is that right?
That's correct, Justice Alito.
And the Fifth Circuit decision does not prohibit you from continuing to produce and sell that product, right?
That is correct.
All right. And so I gather your injury is that you think you're going to sell more if the restrictions that previously were in place were lifted.
Yes.
So you're going to make more money.
The injury is that we are prevented from selling our product in line with FDA's scientific judgment about the safe and efficacious use of the drug.
And you're going to be harmed because you're going to sell more.
I think that certainly a company's ability to market its product is a part of how it considers the regulatory scheme that governs its conduct.
During the questioning of the Solicitor General, the statement was made that no court has ever previously second-guessed the FDA's judgment about access to a drug, right? And it's never second-guessed that.
That's correct.
Do you think the FDA is infallible?
No, Your Honor. We don't think that at all, and we don't think that question is really teed up in any way in this case.
Has the FDA ever approved a drug and then pulled it after experience showed that it had a lot of really serious adverse consequences?
It has certainly done that, and Your Honor, I think that underscores why the adverse event reporting, the post-market surveillance that FDA does, the ability that these plaintiffs have, even if they don't have standing, certainly if they are seeing patients who are presenting with adverse events, if they are doing studies that show there is some unknown safety component that FDA should acknowledge, they can take significant steps to bring that to the agency's attention, to bring that to Danco's attention.
But don't you think the FDA should have continued to require reporting of non-fatal consequences?
Your Honor, the FDA decided not to continue that reporting requirement in 2016 based on more than 15 years of a well-established safety profile when that reporting was required. There is no drug on the market today under any REMS that requires the kind of reporting that the plaintiffs are saying should be reimposed here.
So why would that be a bad thing? Wouldn't your company, I mean, you don't want to sell a product that causes very serious harm to the people who take your product relying on your tests and the FDA's tests. Wouldn't you want that data?
Your Honor, that data is certainly something that we are looking for all the time. It is part of the reporting obligations for a manufacturer to be aware of any data that's becoming available through any means. We have a 1-800 number on our website. There's a 1-800 number on the labeling. I think Your Honor's question, though, gets at concern I heard in some of the earlier questioning about who would have standing if these plaintiffs don't have standing. And one of the things I want to note is that drug manufacturers are very frequently subject to tort litigation. Product liability suit, failure to warn suits, deceptive advertising suits when someone is claiming harm from a pharmaceutical manufacturer's product. What is so, I think, revolutionary really about the arguments here, both on standing and the merits, are the way that they attempt by individuals who do not use this product, do not prescribe this product, and have a conscience right not to treat anyone who has taken this product. Those individuals want to prevent anyone else from using it in line with FDA's considered scientific judgment.
Does your company, just one more point along the same lines, does your company think that what the FDA has done preempts state laws that prohibit the dispensation of Mifepristone within their borders?
We have not taken a position on that issue, and it has not been teed up in this case.
What is your company's position on it? You haven't even thought about it? One of your competitors made that argument, right?
That's right. There are some lawsuits that have been brought by the generic company that do make that argument, and I think that is for later courts to sort out. Our position in this case has been that this is about FDA's scientific judgments reached in 2016 and 2021.
So you don't want to answer that question?
I don't think we have a position that's on that I'm prepared to say today.